Check. Mic check. 1, 2, 3, 4. Hello. Hello. 1, 2, 3. Hello. Hello.
Sir.
Hello. Mic check. 1, 2, 3, 4. Hello. Hello. Mic check. Hello.
ప్లే కొట్టాలి.
వచ్చింది కదా సార్, మళ్ళీ ఒకసారి పెడదాం ఆగండి, అది కొంచెం ఒకటే పాయింట్ వచ్చింది. మీకు ఫార్వర్డ్ చేస్తాను.
ఎట్లా సార్ సార్ చేసి
Check. Mic check. 1, 2, 3, 4. Hello. Mic check. Hello.
లేవు కానీ ఆడియోలో డిస్టర్బెన్స్ వస్తుంది. ఒకసారి ఆడియో చూడమని సార్. ఏం లేవు
అన్నీ వస్తాయి. మైక్లోనా?
Hello. Mic check. 1, 2, 3, 4. Hello. Check. Mic check. 1, 2, 3, 4. Hello. Mic check. Hello. Check. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16.
ప్లీజ్.
Hello. check. 1, 2, 3, 4. Hello. Hello. Check. Mic check. Hello. Check. 1, 2, 3, 4. 1. Hello. Hello. Test mic check. Mic check. Live అయినట్టు సార్. 1, 2, 3. Hello. సార్ డిస్టర్బ్ ఆడియో ఇక్కడ మ్యూట్లో ఉంది. ఓకే.
యాంప్లిఫైర్ నుంచి 3 అవుట్ తీసుకొని కెమెరా వేయాలి. మిక్సర్ పెట్టి మంచిగా బ్లాక్ మ్యాజిక్ ఉంది కదా దాన్ని పెట్టిన మైక్ 1 మైక్ 2 ఉంది కదా, అందులో మైక్ 2లో ఉంది. బ్లాక్ మ్యాజిక్ తీసాను. దేనికని చేయాలి? ల్యాప్టాప్
డిస్టర్బ్ ఆడియో మ్యూట్లో ఉంది సార్. డిస్టర్బ్ ఆడియో కింది. ఓకే. హలో. చెక్ మైక్. హలో. హలో. 1, 2, 3, 4. హలో. మైక్ చెక్. హలో. హలో. కెమెరా సార్ మార్చచ్చు. అది ఇక్కడ చేంజ్ చేశాను కదా సార్. ఇది ఒక్క నిమిషం. ఇప్పుడు చూడండి సార్ ఒకసారి. మైక్ చెక్. హలో. ఇక్కడ ఆడియో ఇన్పుట్ డెస్క్టాప్ ఆడియో ఉంది కదా సార్. మిక్స్ యాక్షన్ ఉంది. డైరెక్ట్ పెట్టినా సార్. ట్రయాంగులర్ సార్. నేను ఆనంద్ మాట్లాడుతున్నా. డైరెక్ట్ పెట్టినా సార్. హలో. మైక్ చెక్. 1, 2, 3. హలో. హలో. హలో.
పెట్టింది సార్. ఈ మిక్స్ అవుట్ కూడా వస్తున్నాయి సార్ అన్నారు. ఇవి ఆఫ్ చేయాలి. ఇది కూడా చూపిస్తున్నా మిక్స్ యాక్షన్.
ఆక్స్ అనేది కింద బంద్ చేద్దామా సార్? ఇక్కడ ఇది ఏమైనా చూడండి కింద తాడిది అది కూడా ఇది కెమెరా వాట్సాప్ కాదేనా?
లేదా సార్
వాట్సాప్ కాల్.
హలో. మైక్ చెక్. 1, 2, 3, 4. మైక్ చెక్. 1, 2, 3, 4. మైక్ చెక్. హలో.
ఒకసారి వేరే
మైక్ చెక్. Hello. Hello. Check. Hello. Hello. 1, 2, 3, 4.
మైక్ కాడికి వస్తుంది.
Check. Hello. Check. 1, 2, 3, 4. Hello. Check. 1, 2, 3, 4. Mic testing. Hello. Hello. Check.
చూడండి సార్.
సార్ గాల్లో వస్తుందా లేకపోతే దీంట్లో వస్తుందా అర్థం కదా.
అదే కదా.
Check. 1, 2, 3, 4. Check. Let's check. 1, 2, 3, 4. 1, 2.
ఆఫ్ చేసి మాట్లాడు మళ్ళీ ఫ్రెండ్ ఆఫ్ చేసి మాట్లాడు.
Hello. Check. 1, 2, 3, 4. 1, 2, 3, 4. Check. 1, 2, 3, 4. 18th NALSAR Justice Bodhraj Sawhny Memorial Moot Court Competition.
ఇప్పుడు ఆఫ్ చేసి మాట్లాడు. అంటే లైట్స్ ఆఫ్ చేసి మాట్లాడు.
Hello. Check. Hello. Check. 18th NALSAR Bodhraj Moot Court Competition in Moot Court Hall 2025. Hello, check. 1, 2, 3, 4. Hello, 1, 2, 3, 4.
చూడండి సార్.
బాగుంది, నో ఇష్యూస్.
Okay.
This? No, wait. Small basic is working. Like, this? It's good.
Your Lordships, am I audible? Yes. Your Lordships, you will be representing the respondent side. The team code is 02, Your Lordships. Thank you, Your Lordships.
Your Lordships, we'll be representing the appellants and the team code 66.
Mic is not very clear.
Hello. Your Lordships, am I audible?
No, too much interference in that mic. Now when you speak, the words are getting garbled. Can you just speak again?
Your Lordships, am I audible?
Audible, but it's not very clear. Maybe you can try speaking without the mic.
Right.
No, take the mic little more towards you. Adjust your height.
Yeah, that's easy.
Your Lordships, am I audible?
Yeah, this is much better.
Your Lordships, we are the team representing the appellants and we are team code 66.
Petition side to be comments. Yes.
Your Lordships, am I audible? May it please the Honorable Court. I, Arya Mikkari, along with my co-counsel, Mr. Anish Padhyay, respectfully enter appearance before this Honorable Court on behalf of the appellants in the present case. Your Lordships, the Council recognizes the presence of your Ladyship and seeks permission to collectively address the bench as your Lordships. Much obliged, Your Ladyship. Your Lordships, the Council will be arguing 4 issues before this Honorable Court. And we humbly pray that the Legislative Assembly of Gurmania possesses the legislative competence to enact the FLRA or the Family Law Reform Act of 2023, and the same is not repugnant to the central legislature, that is the BSMA. Second, the states of Bharatapura are constitutionally obligated to recognize relationships registered under the FLRA on grounds of the full faith and credit clause enshrined under Article 261 of the Bharatapuran Constitution. Third, the impugned adoption provisions are violative of Article 14 and Article 15 of the Bharatapuran Constitution. And finally, the High Courts have authority under Article 226 to set aside the policy of Beta Bank. Your Lordships, with the prior permission of this Court, the Council seeks permission to proceed with the submission of the facts. Much obliged, Your Lordships. Your Lordships, the matter before this Court today touches not only upon questions of legislative competence and constitutive interpretation, but also touches upon the very ideals of justice, equity, and liberty that are embedded into the fabric of our Constitution. Your Lordships, Gurmania has always been a torchbearer of progress and equality within the state of Bharatapura. In accordance with that, we enacted the Family Law Reform Act in 2023. Your Lordships, the concept of queer marriages is not new to the state of Bharatapura. Notably, Your Lordships, devout pandrins, which comprise of almost 1/3 of the Bharatapuran population, allow for homosexual marriages within the community. Therefore, Your Lordships, this Council will be dealing with the first 2 issues before this Honorable Court. Your Lordships, the Council seeks permission to proceed with the first submission. Much obliged, Your Lordships. Your Lordships, the Council will first be establishing the legislative competence of Gurmanian legislature and then deal with the question of repugnancy under Article 254. Your Lordships, the cornerstone of federal constitutionalism lies in the division of legislative powers. Article 246 of our Constitution provides that Union and the states may legislate upon matters enumerated in List 1, List 2, and List 3 of the 7th schedule. Your Lordships, Entry 5 of List 3 expressly empowers both legislatures to make laws on marriages, divorce, and adoption. Therefore, Your Lordships, Gurmania's legislative competence flows directly from the Constitution itself. Your Lordships, the aspect of queer marriages can also be recognized by the state legislatures. Your Lordships, this court in the Superior versus Union of India judgment made it clear that recognition of queer marriages is a matter for the central.
Not this court, counsel, it is the Indian Supreme Court, not binding on us.
Right, Your Lordships. I apologize, it is the Indian Supreme Court. Your Lordships, the Indian Supreme Court in the case of Superior versus Union of India made it clear that recognition of queer marriages is a matter for the legislature. Your Lordships, just to provide a clarification, the laws of Bharatapura are para-material to that of India. Your Lordships, since the Council has established the legislative competence of the state of Gurmania, the Council seeks permission to proceed and deal with the question of repugnancy in the present case. Much obliged, Your Lordships.
Who are the council?
Yes.
The council seeks permission, you did not say. Who are the council? Usually informs the proceedings.
Right, Your Lordships. Your Lordships, the Supreme Court in the case of Deep...
Yes.
Your Lordships, the Supreme Court in the case of Deep Chand versus State of UP called out 3 types of repugnancies that arise in a given case. First, when there exists direct conflict between the two provisions. Second, when Parliament, through its enactment, intends to occupy the entire field by laying down an exhaustive code, Your Lordships. And third, when both Parliament and state laws operate within the same legislative field. Your Lordships, the Council submits that there does not exist a direct conflict between the two statutes and enactments. Your Lordships, to determine whether there is direct conflict, the test of simultaneous obedience needs to be applied. Your Lordships, this test was also applied in the case of West UP Sugar Mills Association, where the Supreme Court held that repugnancy requires more than superficial inconsistency, and that the
Counsel, isn't the inconsistency here at the very core of the legislation? Because one legislation says this is not a valid marriage, one legislation says this is a valid marriage.
Right.
Isn't it? I mean, I can't think of an inconsistency which is more obvious than that. How do you say there is no inconsistency?
Right, Your Lordships. Your Lordships, the Indian Supreme Court, in the case of Superior versus Union of India, maintained that the intent of the central legislation in question, that is the BSMA, was to...
I'm not necessarily saying the BSMA.
Right.
Because BSMA is not the only legislation in the concurrent list, in the context of personal laws.
Right, Your Lordships.
It's all the various communities' codified personal laws as well. Except for the codified law of the Pandurans, which applies only between 2 Pandurans.
Right.
There is no question of recognition of queer marriage. In that context, isn't there a fundamental inconsistency between all the central laws here and the state law?
Right, Your Lordships. Your Lordships, to again cite the Superior judgment, the Indian Supreme Court held that the state and central legislation had the power to recognize the aspect of queer marriages. Your Lordships, the BSMA specifically was...
Which judgment in the Superior case? Because there was a majority and a minority judgment.
Your Lordships, the majority judgment.
Authored by?
Your Lordships, Justice Bhatt.
Could you point us to the relevant paragraph, please?
Yes, Your Lordships. Could I just take 10 seconds and...
Yeah, sure.
Paragraph. Your Lordships, the Council does not have the exact paragraph at the moment, but it was held in the majority judgment.
When you say it is held, you are talking about the ratio decidendi of the case. We can't rely on a passing observation. The question of Superior was not a question of a state legislation versus a central legislation. It was only the constitutionality of the central legislation. So the question that you are saying it held, it did not actually hold. It just made a passing observation.
Right.
Passing observations of courts nice to know, useful to read, but cannot constitute the law laid down by the court in that context. So I don't think you can rely on Supreme for this particular proposition.
Your Lordships, the Council would like to humbly disagree. Your Lordships, the Supreme held that the Special Marriage Act was the legislative intent of the Special Marriage Act, the Indian Special Marriage Act, Your Lordships, was a progressive law at the time of its enactment in 1954. Your Lordships, the legislative intent behind the enactment of this Special Marriage Act was to allow interfaith and intercaste marriages. Your Lordships, the court, when discussing the applicability of the Special Marriage Act to queer marriages, held that the BSMA could not be broadened to include the aspect of queer marriages.
All of that is very good, but the BSMA also does something very specific. It says marriage can only be between one man and one woman.
Right.
Forget about the intent. That is the literal words of the act.
Absolutely.
Right? So in that context, when it says that marriage cannot be between two men or between two women, how can we say that there is no conflict?
Right. Your Lordships, the Council agrees with Your Lordship's contention that the BSMA does not warrant for recognition of queer marriages. Your Lordships, however, this court has already, the Indian Supreme Court has already stated that recognition of queer marriages is a matter for state and central legislatures.
See, again, like I said, when it says held,
Right.
it was not as if the court there was deciding the case where there was a state legislation.
Right.
It made a passing observation. It is not the binding law laid down by the Supreme Court of India, which
Absolutely.
is not even binding on courts in India.
Absolutely, you're
Right? So in some senses, that's a passing observation. Can you point us to the text of our constitution here, right? Or to the text of the laws to show that there is no consistency. Sorry, there is no inconsistency here.
Right. Your Lordships, this argument that there is there is an inconsistency between the provisions of BSMA and the FLRA will not stand, Your Lordships. Your Lordships, it can very well be argued that the aspect of timeline differences or the aspect of residency requirement or the difference between the residency requirements and the difference between the timelines, Your Lordships, is giving rise to inconsistency for the purposes of repugnacy. Your Lordships, the Council, when dealing with this issue, cited the case of West UP Sugar Mills Association, where the court held that repugnancy required more than superficial inconsistency. Your Lordships, in the present case, these provisions with respect to the timeline differences are only superficially inconsistent and cannot qualify under the test of repugnancy. Your Lordships,
I'm saying a more fundamental point. The fundamental inconsistency is BSMA and all the other legislations say marriage, save with one exception, is between a man and woman, and this legislation says marriage can be between two people of the same gender, like where marriages are recognized. Is that not a fundamental inconsistency between the two legislations? It's not a superficial law. Right. Law A says this is not possible. Law B says this is possible. Right? Is that not a fundamental consistency?
No, Your Lordships, it cannot be a fundamental inconsistency. Your Lordships, for the purposes of this, we again to reiterate, Your Lordships, we need to look at the legislative intent of the Special Marriage Act. Your Lordships, if the Special Marriage Act...
Why do you get to legislative intent again and again? Because I'm giving you the provisions. If there is, you go to legislative intent only if the provisions are not clear. Here they are clear as daylight. Right. I don't think anybody here is making the argument that gay marriages are allowed in BSMA, in which case you go to the intent. Right. It is not. It is clear as daylight that BSMA only and all the other legislations only allow for heterosexual marriages. So what does the intent matter here?
Right, Your Lordships. Your Lordships, the intention would be important in the present case, Your Lordships, because if the intention of the BSMA was to only apply...
Counsel, I'm sorry, the observation came from the bench says, can you go to
Can you at all go to the intent?
the text of the provision is what needs to be interpreted. In what cases can you rely on intent?
Your Lordships, the intention needs to be looked at when the texts of the provisions are inconsistent. Your Lordships, the intention needs to be looked at so as to harmoniously construct the application or the simultaneous coexistence of the two enactments, that is the BSMA.
Sorry, you are saying too many things. Let's just be very clear. In what cases would you resort to intent of the legislature?
Your Lordships, I couldn't hear you.
In what cases would you resort to looking at the intent of the legislature?
Your Lordships, the court shall look at the intent of the legislation when the provisions are, Your Lordships, prima facie inconsistent. However, Your Lordships, the intention, when we look at the intention, we can very well establish the fact that the particular enactment did not warrant for expanding the scope of marriage laws within the territory of Bharatapura, Your Lordships. Right. Your Lordships, if there are any further questions, the Council would like to deal with that at this stage.
Before that, with regard to the consistency or
Your Lordships, I'm so sorry, you're not audible.
inconsistency with respect to both the legislatures, which was the judgment to start with, Karunanidhi or something like that?
Apologies, I couldn't...
Karunanidhi's judgment.
Right, Your Lordships. Your Lordships, the question of repugnancy was first dealt by this court in the case of Saver by Amaidas versus State of...
That's what my brother is asking with respect to that.
Sorry. Yeah. No, the question is, in the context of repugnancy, what is that test and how would you sort of say that these two legislations are not inconsistent? That is what I think we are trying to...
Your Lordships, for the purpose of repugnancy, we need to apply what is known as the simultaneous obedience test, where the court needs to look at the fact that whether there is direct and irreconcilable conflict. Your Lordships, in the present case, direct conflict cannot be established since the provisions of the BSMA and FLRA are not contradicting each other. Your Lordships, the FLRA is merely making an attempt to broaden the scope or broaden the horizon of marriage laws within the country, as they rightfully can do so under as the subject is under entry 5 of the third list. Your Lordships, more so, it cannot be considered irreconcilable as well, as Section 7 of the FLRA, which is present in the first annexure to the Moot proposition, if you can refer to that, Your Lordships, maintains that allows for non-registration under the FLRA, leaving the citizens or residents of Gurmania to register under either the FLRA or the BSMA. Therefore, Your Lordships, this, in the present case, it is not giving rise to a direct or irreconcilable conflict for the purposes of repugnancy. Your Lordships, seeing that I lack time, the Council would like to seek permission to proceed with the second submission. Much obliged, Your Lordships. Your Lordships, I now turn to the second issue. This issue lies at the very heart of federal unity. For the purpose of this issue, the Council would like to place reliance on, the Council would like to submit two arguments. First, the constitutional command of the full faith and credit clause enshrined under Article 261. And second, the inapplicability of the provisions of Article 245, which talks about the doctrine of territorial nexus. Your Lordships, Article 261 requires that full faith and credit be given throughout the territory of Bharatapura to public acts, public records, and judicial proceedings of every state and of the Union. Your Lordships, the certificates of registration, which are issued under the FLRA, are public records within the meaning of the provision. Your Lordships, to deny recognition to such certificates would be to deny the constitutional mandate itself.
I don't think anybody is denying the validity of the certificate.
Right.
What they're saying is the certificate will not have the same legal effect as you expected.
Right.
Simply because what you're asking the state of Canaria to adopt is the legal fiction.
Right.
That the state of Gormania has put into its law.
Right.
Correct? That is to state this is on par with a marriage.
Right.
No one is saying the certificate is not valid. No one is saying it is void. It's simply being said that the legal fiction under this act cannot apply outside the territory of the state of Gormania.
Absolutely.
That is what is being said. So I'm not sure how 261 applies here.
Right, Your Lordships. Your Lordships, in the present case, Article 261 has high applicability. Your Lordships, Article 261 is not a mere evidentiary provisions as envisioned by your lordships. Your lordships, to provide a clarification and to cite the judgment of Andhra Pradesh High Court, where the...
Which case is this?
Just 1 second, your lordships. Apologies, your lordships. The case was Palgao Cotton Mills Limited versus Jairam Jaidar. It was a case...
What are the facts of this case?
Right. Your lordships, in that case, your lordships, the question before the court was whether the Bombay Relief Undertaking Special Provisions Act could be given effect in the state of Andhra Pradesh in light of Article 261. Your lordships, the court...
Which specific provision of the Bombay Undertakings Act?
Your lordships, I believe I am not aware of the specific provisions of the
How can we apply the principle without knowing the facts?
Your lordships, in the case, in the judgment of the Andhra Pradesh High Court, the High Court gave full effect to the provisions of the Bombay Relief Undertakings Act in the state of Andhra Pradesh.
But what did the provision say? That's the point, right?
Right.
That's what we're trying to understand. Because if you are saying that this legal fiction has to apply outside the borders of a state, right? You're asking for extraterritorial application of a law.
Right.
Now, under Article 245, a state has constitutional power to make a legislation that applies only within the territory of the law.
Right.
Correct? Oh, sorry, territory of the state.
Right.
What is being requested here is for the state of Canada to also apply that legal fiction.
Right. Absolutely.
So, which part of the constitution allows for this?
Your lordships, Article 261 deals with the legislative relation, deals with the administrative relations between the center and the state. Whereas Article 245 deals with the legislative relations between the center and the state. Your lordships, in the present case, even if the court does not agree with the contention of the appellants in the present case, that the FLRA must be given recognition in the state of Canada.
No one saying the FLRA has no recognition.
Right.
It is only in the context of the FLRA saying that as far as the legal fiction is concerned, a relationship registered under FLRA should have this, will have the same legal status as a marriage under any of the other central legislation. That is what is being questioned.
Absolutely.
Because central legislation, there is no doubt, applies across the country. State legislation is only limited to the territory of the state.
Right.
So how can we, through Article 261, extend the application of a state's laws outside the boundary of a state?
Right, your lordships. Your lordships, for the... your lordships, I'll just take one moment and I'll answer that.
Time is up, so...
Yes, before that I would like to seek an extension and I'll just take 10. Your lordships.
You seem to have taken a little of time.
Sure.
So give him more, some more time.
Right, much obliged, your lordship, much obliged. Right. Your lordships, in the present case, for the purposes of Article 235, we need to look at the doctrine of territorial nexus. Your lordships, this doctrine of territorial nexus, the Indian Supreme Court in the case of R&D Chamabarwala laid down two tests for the purposes of establishing whether the doctrine of territorial nexus can be applied. First, whether there is whether the connection is real and not illusionary. And second, whether the liability which is sought to be imposed is pertinent to that connection. Your lordships, in the present case, the couples which are registered under the FLRA, when they are relocated to another state, they are merely seeking recognition of the same legal status. Your lordships, not because the FLRA seeks to directly regulate persons.
Sorry to interrupt. Let's make it very simple. You have a GST registration certificate.
Right.
Under Section 24 of the GST Act, you get a certificate that recognizes the place of business.
Right.
Now, can a person, analogous to your argument, say in Article 261, my place of registration is Telangana, it's
Right.
Hyderabad. but I want to go into business in Bangalore on the strength of the same certificate.
Right.
Is that permissible?
Your Lordship, sorry,
Is that permissible?
Right. Your Lordships, I believe that the Council believes that the comparison is not right. Your Lordships, the comparison of a sociological issue to that of an economic or a business issue is not permissible. This court has held this in the case of state, the Bombay High Court, Your Lordships, has held this in the case of state versus Narayan Manilal, Your Lordships, and held that the comparison between sociological issues and economic or business related issues is not valid, and therefore, Your Lordships.
What are the facts in Narayan Manilal?
Just 1 second, Your Lordships. In that case, the question before the court was that whether the bigamous, whether the state enactment of Bombay, which dealt with bigamy, Your Lordships, could have extraterritorial application.
And what was being compared on the economic side?
Your Lordships, the doctrine of territorial, the court considered the applicable.
Advice from bench, which we rarely do. If you don't know the facts, please don't cite a judgment.
Right, Your Lordships.
Please don't, in the course of your arguments, don't cite any judgment that you don't know the facts.
Right, Your Lordships.
Right?
Yes, much obliged.
So come back and try to answer. On the same analogy, I say Article 261, my GST certificate of Hyderabad should be valid in Bangalore. So you want to derive a benefit out of a status,
right,
recognized by a legislation. That legislation, you can't disagree, operates in the four corners of the territory in which the legislature has enacted that legislation.
Right.
Now, if you want a benefit out of it, you have to remain in that state.
Right, absolutely. Your Lordships, but for the purposes of the extraterritorial applicability, the two-pronged test also needs to be applied. Your Lordships, in the case which is, in the hypothetical situation which is presented by Your Lordships, the connection is pertinent to the liability which is imposed, because the tax is not pertinent to the liability which is imposed, because the connection has no applicability outside the limits of that particular, outside the geographical limits of that particular state. Your Lordships, however, in the present case, marital rights are not confined to a particular territory. They expand outside the territory of a particular state and impose legal consequences outside territories, Your Lordships. Therefore, it is not a fair comparison to a fair argument to compare a business legislation or business issue with a sociological issue. Right. Your Lordships, I see that my time has elapsed, and it was an honor arguing before this court, and I would like to invite my co-counsel to deal with the second two issues. Much obliged, Your Lordships, and I thank the court for its time.
Please the Honorable Court, I, Anish Padhe, enter appearance before the Honorable Supreme Court of Bharatipura on behalf of Khushim. May it please the Honorable Court, I, Anish Padhe, enter appearance before the Honorable Supreme Court of Bharatipura on behalf of Khushim and Narmira, the appellants in this case. Your Lordships, the Council shall be arguing the final two questions before the Court today, which deal with whether Section 57 of the JJ Act and Regulation 5.3 of the Adoption Regulations are constitutional or not, and secondly, that whether High Courts have any authority at all to set aside the policy of Beta Bank for being discriminatory towards the LGBTQ+ community. Your Lordships, the questions which the Council is dealing with at the present moment arise from a common grievance of the appellants. In this case and in these questions, Your Lordships, the appellants have been discriminated against on the basis of our sexual orientation. With respect to the third submission, Your Lordships, the Canadian Adoption Resource Agency has taken recourse to Regulation 5.3 to deny us adoption rights, although we wish to adopt a child in the state of Canada. And with respect to the fourth submission, Beta Bank is denying us transfer to the state of Canada and the city of Meerahalli, although our job is a transferable job, and merely because we have registered our relationship under the FLRA. Your Lordships, we stand before the court today to oppose both of these actions and establish equitability. Your Lordships, I seek permission to proceed ahead with the third submission. Your Lordships, for the third submission, we argue four grounds. Firstly, that the classification which section 57 creates between married couples and unmarried couples is violative of Article 14 of the Constitution. Secondly, that section 57 of the JJ Act is manifestly arbitrary and temporally unreasonable. Thirdly, that section 57 of the JJ Act violates the principle of essential legislative function. And lastly, that regulation 5.3 of the adoption regulation indirectly discriminate against the queer community and violate Article 15 of the Constitution. Lordships, section 57 of the JJ Act was enacted after ratifying the Convention on Rights of Children, specifically Article 21. Your Lordships, the preamble of the CRC explicitly states that while enacting laws on adoptions, state parties are not to discriminate on the basis of sex, class, race and other criteria. Your Lordships, other criteria would also include sexual orientation for the meaning of Article 15 of the Constitution as held by this court in the case of Navteej Singh Johar. Your Lordships, we argue before the court that both the classes, married couples and unmarried couples, are similarly situated. Therefore, any classification in both of these classes is in teeth of Article 14 of the Constitution. Your Lordships, the Indian Supreme Court in the case of Deepika Singh versus Central Administrative Tribunal has extended familial rights and the right to form a family to atypical unions or atypical families as well. Your Lordships, the court has held and atypical families also include unmarried couples and queer couples, Your Lordships. The court,
Just getting the names it cannot be sufficient.
Your Lordship, I cannot,
You have to give the specific citations also.
most certainly.
Both of you who were just, you were just referring the names and leaving it. That's not correct. Okay, proceed. Yes,
Your Lordships, Deepika Singh in paragraphs 23 and 20.
specifically note down the citations also.
Not paragraph. Paragraph is noted.
Your Lordships, it is a judgment of the year 2023 and it was reported by SCC online and paragraphs 23 and 24 of the same case.
You can give SCC online so also such as.
Yes, Your Lordships. In that case, Your Lordships, the court has extended equal constitutional protections even to atypical unions. And Your Lordships, we argue before the court that adoption is a very seminal constitutional protections which atypical unions such as unmarried queer couples ought to be given. Your Lordships,
So you're right about saying ought to be given, but can it be done by an order of the court? That's the question to be asked, because if you look at what you're asking for is essentially to put an end to the adoption process entirely. Section 57, you're asking us to strike it down. What is the consequence of striking it down? No one can adopt any child. How does that benefit the child? The purpose of the legislation is to protect children. You're asking the court to defeat the purpose of the legislation to say this. We're not saying your claim is wrong. We're saying the way you're asking for it is self-defeating.
Your Lordships, we argue before the court today that section 57, specifically section 57 subclause 2 of the JJ Act, which includes the word spouse, should be expanded to also include homosexual.
No, that you're asking a very different relief now. See, you can either say this is a violation of the Constitution, strike it down, or you can say that the provision has been wrongly interpreted by whatever, this adoption agency, and the word spouse should include more than just legally married spouse. These are two different things you're asking for. Please be clear what you're asking from this court. Because you started off by saying it's manifestly arbitrary, strike it down. And I just pointed out to you that that is self-defeating because it means no one can adopt. So now you have changed your stance. So please be clear what is your stance.
Lordships, we argue before the court today that as held by the Supreme Court in the Indian Supreme Court in the case of Supriyo. In the case of Supriyo, Lordships, the Supreme Court recognized that these provisions indirectly discriminate against the queer community.
What is your prayer? Make yourself clear.
Yes, Your Lordship. Yes, Your Lordship.
But it's something outside of the entire regulation.
Your Lordships, no. The appellants in the present case are seeking the writ of mandamus for expansion of the word spouse within the meaning of section 57 subclause 2 of the JJ Act.
How does a mandamus help you?
Your Lordships, that would be a direction to the legislature to interpret.
Can the court direct the legislature?
Yes, Your Lordships.
In what way?
Your Lordships.
Give us some
Can the
instructions.
legislature interpret?
Sorry, Your
You
Lordships.
are asking the legislature to interpret.
Lordships, the judiciary will interpret it by expanding the meaning of the word spouse under section 57 subclause 2, which would also include homosexual couples, which is currently not the interpretation which the judiciary is going by, your leadership. And Your Lordships, to answer your question of certain instances being covered by this particular, by the question posed by Your Lordships, the Canadian Supreme Court in the case of K&B Ray, and Your Lordships, we have made recourse to this judgment specifically because even the Family and Child Service Care Act of Canada includes the word spouse under section 67, and even section 57 subclause 2 mentions the word spouse. That is why, Your Lordships, we argue before the court that the word, and in that case, the Canadian Supreme Court expanded the meaning of the word spouse to also include homosexual couples because it deemed that not doing so would be unfair and discriminatory towards the queer community. And Your Lordships, on those grounds, we seek expansion of the meaning of the word spouse. If that answers your question.
Then this court would cater to the welfare of the queer community. Should this court not be mindful of the possibility of abuse it may bring? You know the extent of trafficking that's involved, right? So what happens if two persons pretend, because they're not bound by anything in law, but they pretend that we are a couple and we must be allowed adoption, and then something wrong happens to the child?
Your Lordships, the precise answer to this question would lie in our interpretation of Regulation 5.3 of the adoption regulations. Now, Your Lordships, Regulation 5.3 lays down two criteria, it imposes two criteria, the criteria of stability and the criteria of marriage. Your Lordships, the appellants do not dispute the fact anywhere that stability should be a mandate in order for prospective adoptive parents to adopt under the framework of the JJ Act. What we dispute and what we disagree with is the additional burden of marriage, which makes the entire regulation 5.3 disproportionate and onerous on queer couples because currently they do not enjoy the right to marry as far as the Republic of Bhartipura is concerned.
Counsel, as an officer of the court, you'll have to assist us. What happens if we remove the institution of marriage, right, from the requirement? Then possibly two people who are cohabiting together and who may be non-subscribing to any gender, who may be subscribing to the same gender, it could be anything. But tomorrow they part ways, then what happens to the welfare of the child?
Most certainly. Your Lordships, the answer to this question lies in our argument that the criteria of marriage has no nexus at all with the object of the JJ Act and section 57, which is the enhancement of best interest of children. So Your Lordships, to answer this question, we have to juxtapose marriage as a criteria with the principle of best interest of children. And we submit before the court that marriage as a criteria not having marriage as a criteria would not have any different effect on legal entitlements and rights of children who are adopted.
How so?
Yes, Your Lordships.
No, I just wanted to add to a question there. Look, marriage is not just a fact. Marriage is an entire legal structure. Once, for instance, if you get married under the DSMA, you are covered therefore under the inheritance laws. You are covered if you are married under one of the other personal laws, you are covered under the entire structure of personal laws. And all these personal laws talk about how divorce takes place, what court will do. For instance, in the context of India, the Hindu code as such covers everything, right? So it's not just a fact that no marriage is not just about that one act of, Saptapadi or anything. It is, you are getting into an entire legal framework. So, to me, your argument does not hold that it's not a big deal.
Yes, Your Lordships. To answer both of Your Lordships' question, the Council shall take recourse. Firstly, I'll answer it in two ways. Firstly, I'll answer on the framework of the JJ Act, and then, as Your Lordships mentioned, juxtapose it with other legal protections of maintenance, custody, etc. to argue why marriage is unreasonable. Your Lordships, Section 63 of the JJ Act creates a deeming fiction that children adopted under the framework of the JJ Act shall have all legal rights and entitlements equivalent to biological children of a couple, your lordships. And your lordships, marriage as a criteria does not bode well with this legal fiction. There is an inherent consistency between the legal fiction created under section 63 and section 57, which lays down the criteria of marriage. If children are to be having the same legal rights and entitlements as biological children of a couple, your lordships, then the provisions of JJ Act need to be made consistent with these legal provisions. And your lordships, to answer your second question, which deal with other legal protections, if your lordships take recourse to provisions such as section 125 of the CRPC or section 20 of the Hindu Adoption and Maintenance Act, these provisions do not require a marital status of parents with respect to the relationship between children and parents. They also deal with protections given to illegitimate children.
That's a very limited set of protections. For instance, again, in the Indian context, if you take the Hindu Succession Act, the children who are not born out of legitimate marriage cannot be part of the co-parsonary. Correct?
Yes, your lordship.
So here again it is making a distinction. I'm just giving you one example out of 20 different examples across different legislations governing customary laws. So in all of these laws there is a distinction between children born for both. There is some common minimum threshold, but you cannot say there is absolutely no distinction between, otherwise then these words would have been meaningless. This legal fiction was not necessary. If the laws already treated all children, whether they are born within the marriage or outside the marriage, as equal, then this distinction would not have been needed, right? I'll come to a second more complicated point, and here is again where our argument is self-defeating. By saying marriage or spouse, the rules and the act are giving a framework to assess stability. It's saying there is this other legislation which has criteria of validity, other legislation which has criteria of when it breaks apart and so on. So you can rely on that to say if they are married, this law takes care of it. In the context of queer couples, except for one state, the other states have not provided for it. So how can we interpret it so expansively without providing guidelines on what is stability? And we are not competent to decide stability. We are not experts in child welfare. So isn't it again, same problem with saying 57 is unconstitutional? Are you not now ripping away the foundation of adoption under this act?
Lordships, firstly to clarify, stability is itself defined under regulation 5.3 on the temporal criteria of 2 or more years.
Yes.
So lordships, that's stability.
But that is also in the context of marriage, correct? Now, how can we say all other relationships are equally the same as marriage? Because again, remember, it's not the fact of marriage, it's the legal framework which comes with marriage. When it's saying marriage, right? When there is no legal framework, how do you assess stability? What is, for instance, we know there is a starting point for a marriage. Every single law says this is the date on which you are married. Whether it is you are agreeing to it in accordance with a particular law or when the rituals are done. In any other relationship, what is the starting point of that relationship?
No, sir.
How do we even start the clock to say 2 years of a stable relationship? When does it achieve stability? At what point do you say these two people are in a stable relationship? Right? These are all frameworks that are needed in the law before you tell us strike the whole thing down.
Your lordships, to answer your question, since it deals with core of interpretation of the JJ Act and reconciling with other provisions, the council shall rely on the principle of purposive interpretation. Your lordships, purposive interpretation demands that the provisions of the JJ Act should be reconciled with other legal provisions which your lordships mentioned to ensure that there is no inequality arising between classes of individuals who are similarly situated. Your lordships,
As a beginning point, you'll have to appreciate, given the lack of legal framework, today you are actually talking about unequals. We have all our sympathies to people of the queer community who do not yet have equal rights because the legislature has not conferred them. But the discussion that is happening in this court, does it not belong to the legislative sphere? Should it not be in the legislature? They must be debating about these things and then evolve a framework. Because look at the pitfalls. You say marriage, the requirement of marriage is superfluous, and you're giving some examples in your answer one. But a relationship which is not bound by marriage is a relationship at will. You cannot exit a marriage at will. You'll have to go through a statutory prescribed procedure to get out of a marriage. But a relationship short of marriage is at will, like partnership at will, correct? So if somebody walks out of that relationship and suppose enters into another one and has a child adopted in both of them, then what happens to the welfare of that child?
Your Lordships,
We are not saying that we disagree with the issues you are raising, but our concern is the court equipped? Are we capable to issue you a mandamus to evolve a framework, an entire framework?
Your Lordships, this court has previously issued writs of mandamus and laid down very extensive broad guidelines and comprehensive guidelines, not broad guidelines, to cover the subject matters of areas where the legislature has not sufficiently enacted laws upon. To provide you with a precedent.
I'm sorry, counsel, again as an officer of the court, we can't be theoretical about these things. You look at countries where there is some sort of protection available to queer community and some measures are there in terms of a regulatory framework to permit even adoption. But look at those countries in terms of their daycare centers, even their creches. How many creches do we have in India? How many daycare centers do we have in India, and the good ones, how costly they are? So what would happen to these children? You're looking at your rights, but what about the rights of those who you want to adopt?
Your Lordships, the purpose of the JJ Act and particularly Section 57, as also accepted by the Indian Supreme Court in Suprio, rests on the doctrine of parens patria, where the responsibility of the state is to ensure and to facilitate adoptions so as to ensure that all children who are currently in need of social integration, reintegration, development and protection, these are words from the object and purpose of the JJ Act, need to undergo the process of the right to adoption to avail their basic rights and needs which ensure their basic interests. Your Lordships, this purpose of the Act is very central to the demand which the appellants are making, the writ of mandamus. Your Lordships, if the court provides guidelines on ensuring that adoption rights be also be equally applied and implemented in case of unmarried queer couples, then the court is ensuring that unmarried queer couples are not left hanging in terms of their familial rights, which, as pointed out by the council previously, they are equally entitled to enjoy. And Your Lordships made recourse to foreign jurisdictions. Your Lordships, I would humbly present before you a case of South African Constitutional Court in the case of Du Toit and others versus South Africa, where the court dealt with the challenge to Section 17 of the Child Care Act. And in that case, the court held this Child Care Act under paragraph 32 and 34 to be unconstitutional because it took note of the fact that queer community has, and the demand for queer rights has expanded a lot in the history of the Republic of South Africa. Similarly, Your Lordships, the facts of the present case are conscious of the fact that queer rights in Bharatipura have been demanded and been accepted by both courts and legislature, specifically with respect to decriminalization, consistently and regularly. That is why, Your Lordships, we argue before the court that an expansion of right to adopt to unmarried queer couples would be in sync with the discrimination which they are facing, and it would remedy the discrimination which the unmarried queer couples currently are facing in the Republic of Bharatipura. If that answers your question. Your Lordships, I seek to proceed ahead with the fourth submission, if Your Lordships permit. Lordships, the fourth submission deals with whether the High Court can set aside the policy of Beta Bank. And the High Court of Kenya, while denying this relief, said that Beta Bank is a private entity, which is why it is not amenable to the jurisdiction of High Courts under Article 226. We challenge this decision of the High Court of Kenya and argue 2 points. That Article 226 includes within its scope the power to issue horizontal writs against private entities. And secondly, that Beta Bank has a legitimate expectation to protect the rights of the queer community. I seek an extension of 2 minutes to summarize the fourth submission. Most certain. Your Lordships, Article 226 has a broader scope than Article 32 of the Constitution. Any rights mentioned in Part 3 of the Constitution can be enforced against any person or authority. the Indian Supreme Court in the case of Zee Telefilms versus Union of India took note of this broad interpretation of Article 226 and it held in paragraph 31 of Justice Santosh Hegde's opinion that Article 226 can be used to prevent private parties from going scot-free for violating fundamental rights of people, merely because they are...
Is it a fundamental right which you are seeking, or is it a statutory right according to you?
Your Lordship, we are seeking the enforcement of a fundamental right. A fundamental
right is you may have a fundamental right. Question is it's legislatively controlled in a particular manner in the context of your challenge.
Your Lordships, the context of our challenge is based on the policy of Beta Bank. Beta Bank is a private bank in the Republic of Bharati.
Beta Bank is a private bank, whether a mandamus could be issued or could not be issued to a private entity is the issue. In certain circumstances, Supreme Court said yes, even a private entity also can be issued with a mandamus. Question is for the issuance of a mandamus, there has to be a pre-existing right. That right is created, in your opinion, is it by statute or is it that declaration you are seeking by way of an expanded interpretation?
Your Lordships, we are seeking an expanded interpretation of Article 15 of the Constitution, and our interpretation deals with the policy of Beta Bank, which is differentiating between two marriage legislations, that is the BSNA. I seek an extension to answer this question, Your Lordships. BSNA and the FLRA. Your Lordships, Beta Bank in paragraph 23 of the proposition is creating the right by saying that the job of Narmira, an appellant, is a transferable job within the policy of the bank. And in paragraph 24, the same policy is being used to differentiate between these two statutes and deny transfer to FLRA couples. And Your Lordships, FLRA couple is the only legislation in the Republic which grants or recognizes queer marriages. That is why, Your Lordships, we seek an expanded interpretation of this right to non-discrimination with the policy of Beta Bank, so far as issuance of a writ is concerned. If that answers
If you failed your certificate of recognition and the FLRA gets rejected, automatically you will fail in the other one, isn't it?
Yes, Your Lordships. Your Lordships, that becomes a question of merit. If the court answers or holds in against us in the second submission that marriage certificate cannot be recognized, then that will be dealt with in the merits of the case when the issue again goes to the High Court of Canada to be dealt with. Presently, what the Supreme Court needs to look at, the court needs to look at with respect to the fourth submission, is whether the High Courts have power to issue writs against private entities such as Beta Bank. And
that could be based on the material available, no, it's not in vacuum. Issuance of a mandamus is not in vacuum, no.
Your Lordships, we seek the enforcement of a writ of mandamus horizontally against Beta Bank as a private entity by relying on the case law of the Indian Supreme Court in the case of Kaushal Kishore versus Union of India. And in that decision, Your Lordships, the court held that horizontality is embedded within Part 3 of the Constitution, and in the ratio, it said that Article 19 and 21 rights can be horizontally applicable against private entities. Your Lordships, what the conduct of Beta Bank is doing in the present case is by differentiating and denying right to transfer to FLRA couples, it is denying us a right to cohabit with our spouse in a territory in which we wish to. And this harms and infringes our Article 21 right to cohabit with our spouse with respect to our autonomy. Which is why, Your Lordships, relying on the rule of Golden Triangle, we seek that this is discriminating against us on the basis of our sexual orientation, and thereby a horizontal writ be issued against Beta Bank as a private entity. If that answers your question. Your Lordships.
Your time is over.
Yeah, I seek, I'll address the prayer and then... Yes. Your Lordships, our counsel for the appellants humbly pray before the Honorable Supreme Court to adjudge and declare that this Legislative Assembly of Romania has the competency to enact the Family Law Reforms Act. Secondly, that the FLRA has an extraterritorial effect in the state of Keneria and other sister states of Bharatipura. Thirdly, that section 57 of the JJ Act and regulation 5.3 are ultra vires of article 14 and 15. And lastly, that the high courts have an authority under article 226 to set aside the policy of beta ban for being discriminatory towards the LGBTQ plus community. May it please the Honorable Court, it was an honor to argue before the court today.
Thank you, Counsel.
The counsel acknowledges the gracious presence of the bench. However, for the sake of brevity of proceedings, seeks the permission to refer to the bench collectively as both your lordships and my lords as appropriate.
No, rather about the even epithets, you can straight away approach the subject.
Thank you, Lordship.
But you have shown your time.
Yes, Your Lordship. Your Lordship, the issue one frame in front of this bench.
Thank the court.
Yes, Your Lordship.
That is my, you are not public, you can, yes, put it up or you can put something behind you keep the books under that.
Yes, Your Lordship.
So that the height will come up. Height will come.
Why don't you move the lectern this side, it may just be easy.
Yeah, you can do it.
You're supposed to be moved.
So not only that, it is actually, the mic has to be little more light. Probably you can keep some books and
I'm not able to Lordships.
Yes.
Your Lordships, moving to the first issue framed in front of this honorable bench, Your Lordships, is regarding the legislative competence of the State Legislative Assembly of Gormania to enact the FLRA. Your Lordships, when the question of competency arises, we have two distinct inquiries. One in Article 245 with regards to territorial competency, and the second in Article 246 read with Schedule 7 with regards to the subject matter competency to enact law, Your Lordships. Your Lordships, the humble submission of the Union is not that no state can enact a law in entry file. Your Lordships, we agree that states can enact law on the subject matter. However, Your Lordships, the Legislative Assembly of Gormania lacked the territorial competency to enact the FLRA owing to the extraterritorial nature of the interim legislation, Your Lordships. If I may direct Your Lordships' attention to Section 6 of the FLRA. Am I, Your Lordships? Yes. Your Lordships, Section 6 of the FLRA clearly specifies that marriages that are solemnized outside the state also, any of Your Lordships, can be very well registered under Section 3. Your Lordships, under Section 3 of the FLRA, the registration needed is only for the residence of 7 days of one of the parties, Your Lordships. Your Lordships, a combined reading of Section 3 read with Section 6 of the FLRA clearly indicates an extraterritorial application to the Your Lordships. Under Article 254, the State Legislative Assembly has competence only to enact a law for a whole or part of their state, Your Lordships, not for the whole of territory of the Union. The Union's contention is that by virtue of both these sections, people throughout the Union can come to Gormania for 7 days, Your Lordships, or only one party has to decide for 7 days. Register their marriage in Gormania, go back to their foreign state and deem recognition for this marriage. Your Lordships, that is presently the case that's happening. The current...
How is it illegal, Counsel?
Your Lordship,
How is it illegal?
Your Lordship, it is not particularly illegal, but the point that the council is making is that it is incompetent to enact such a union legislation by a state legislative assembly.
It is not a union legislation. Take other instances. You had a lot of states who would not charge any motor vehicle tax, any road tax. So you have vehicles, especially the big lorries, go all the way to Nagaland.
Yes,
Get vehicle registered there because they don't have to pay tax there.
Yes,
and these vehicles will be plying all through the country with the required permits.
Yes, Your Lordship.
So would you say that this action of Nagaland in exempting the duty is per se illegal? It is unconstitutional?
No, Your Lordships. For this, I rely on the test established in the case of Charusula Dasi. Your Lordships, the fact pertaining to this particular
Which case is this? Please give a full proper citation.
Yes, Your Lordships. Your Lordships, the state of Bihar versus Saraswati Das, it's a 5-judge bench, Your Lordships. Your Lordships, the fact pertaining to this case cited, Your Lordships, is that it is regarding the Hindu trust and taxation of the Hindu trust, which is in Bihar, Your Lordships. Your Lordships, the Hindu trust held land outside the state of Bihar also. But the court had held that the fact that it held land outside Bihar is incidental. In this case, Your Lordship, the court gave the two-pronged test to prove or disprove territorial nexus, Your Lordship. The first being that the territorial nexus should be real and not illusory, Your Lordships. Your Lordships, here real means it is substantive part of the transaction should be within the forum state, Your Lordship. The state which seeks to be territorially next to the legislation, Your Lordships.
That is the case, in the context of this particular facts of the case, so they should get married once here and then they should also go and get married again.
Your Lordships, can you repeat the question, Your Lordships? I couldn't hear.
If the marriage is to take place,
Yes, Your Lordships.
if they have to get married in one state and then thereafter they have to go to the other state and get married.
Your Lordships, in the present fact under the FLRA, yes, Your Lordships, any marriage under the FLRA, once they go out, they cannot have that marriage intact, Your Lordships. That is why the union is stating that for marital institution to be uniform throughout the country, the only competent legislative body is the union parliament and not the state legislative assembly, Your Lordships. Your Lordships, for this are placed in line from the yes, Your Lordships.
That is contradicted by two express provisions of the Constitution. Number one,
Yes, Your Lordships.
personal laws are placed in the concurrent list,
Yes, Your Lordships.
which means both the union and state can make laws.
Yes, Your Lordships.
Number two, you have Article 261.
Yes, Your Lordships.
It says that these documents, registration, etc. have to be recognized by other states.
Yes, Your Lordships.
So where are you getting this proposition that only the union has the legislative power to recognize?
Yes, Your Lordships. Your Lordships, on the first article that you had cited in front of the council, Your Lordships, the differing opinion of the council is that in such a position, Your Lordships, personal laws are not laws as envisaged under Article 13, Your Lordships. It has been time and again held by the Supreme Court, Your Lordships, that personal laws should not formulate under Article 30.
Purposes of being struck down under Part 3.
But Your Lordships,
Laws under Part 3 are not, that is not the only place in the Constitution where the term law is even
absolutely not. But
So, yeah,
But Lordships, Article 245 mentioning of law cannot be read devoid and independent of Article 30, Your Lordships. Article 30
as it should be. These are two completely different provisions. How can you sort of say law here should mean law here? Let us not look at the context. That's my argument. Therefore, please read the two together. Give us some logic on this.
Lordships, Article 13 does not limit to define law only for Part 3, Your Lordships.
Of course it does. Please read Article 13.
Yes, Your Lordships. Yes, Your Lordships. The article 10 reads as follows. Laws inconsistent with or in derogation of fundamental rights.
Start, yeah, okay. Please start from the start.
All laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. Your Lordships, the definition that the council is seeking here is under subclause 3. In this article, unless the context otherwise requires, law includes ordinance, order, bylaw, rule, regulation.
So if you read 13.1 and 13.3,
Yes, Your Lordships.
right? So far as they're inconsistent with the provisions of this part.
Yes,
So
sir.
when you take 13.3 and put it into 13.1,
Yes, sir.
all it means is ordinance, bylaw, regulation, etc. having the force in law, laws in force insofar as they're inconsistent with the provisions of this part shall to the extent of such inconsistency be void. 245 is giving the power to legislation. So where is the question of
If I may be led to prove how the current nexus of 7 days is illusory. Your Lordships, then I will proceed to answer this question.
Don't jump. I'm just asking a very simple question.
Yes, Your Lordship.
Where is the connection between 245 and 13 and what is a law for the purposes of the Constitution?
Your Lordships, Article 13 has multiple effects, Your Lordships. It has various doctrines inscribed in it and also various definitions, Your Lordships. Your Lordships, when Article 13 defines law, it defines it for the understanding of this Constitution unless and until otherwise the context provides, Your Lordship. 245 does not provide any context which is with default Article 13.
What context is 245 need to say? 245 says subject to the other provisions of this law, the state and union legislature shall have the power to make such laws.
Yes, absolutely.
Are you saying that the state legislature has no power to make a law related to what is a marriage?
Your Lordship, that is not my submission, Your Lordships. Your Lordships, my humble submission is not that no state can make on the subject matter.
So frame your proposition.
Yes, Your Lordship. My humble submission is that the FLRA due to being extraterritorial that is the issue for the competence.
Let's come back to extraterritorial.
Yes, Your Lordship.
First tell me what is extraterritorial about FLRA.
Your Lordship, section 6 read with section 3.
That is not extraterritorial. The registration still happens within the state. Somebody may come from outside the state.
Yes, Your Lordship.
Somebody may go from outside the state.
Yes,
a person who is governed by a state law may go outside.
Yes, Your Lordship.
It does not make the law extraterritorial. The law is saying, the law is saying you can come into our state and register.
Yes.
You cannot sit in your state and register under FLRA.
Yes, Your Lordship.
Isn't that clear?
Yes, Your Lordship.
Where is the extraterritorial?
Yes, Your Lordship. I will comment on that also. Your Lordship, in the case of Ishika Vajina Harima Heavy Industries versus Director of Income Tax, Your Lordships, here the Supreme Court of India held when and where can an informal event amount to creation of a territorial nexus, Your Lordship.
Which state law was the Supreme Court dealing with in that case?
Your Lordship, I am not aware of the particular state law, but I am aware of the subject matter.
Used to be aware, counsel. No side case.
I apologize, Your Lordship, but I am aware of the broader subject matter of the case, Your Lordship. Your Lordship, it was a question between an international transaction of taxation, Your Lordships, whether India as a territory had the territorial nexus for its laws to apply to it.
That should be 245 too.
Yes, Your Lordship. But Your Lordship,
Are you
here,
concerned with 245?
no, Your Lordship, but in this case, the Supreme Court had given general principles regarding 245 subclause 1 also, Your Lordship. Your Lordship, the general principles were there.
It's very simple.
Yes, Your Lordship.
Don't go into the law first. We're asking a simple factual question.
Yes, Your Lordship.
What is it they want?
What is it you are opposing?
They want state legislative assembly to be competent, Your Lordship. We are opposing stating that to hold this legislative assembly competent to enact such a legislation will create a legal scenario in this country, Your Lordships, where every state will have conflicting laws, Your Lordship. There will be uniformity.
Is it that they are challenging the existing law or the power of the legislature?
They are challenging the, sir, Your Lordship, we are challenging the,
One second.
Your Lordship.
Take a second and then understand my question.
Yes, Your Lordship.
Did they challenge the existing law or are they challenging the legislative power?
Your Lordship, they are challenging the existing law, telling that because there is a legal vacuum, we are entering. We on the other hand, the union, Your Lordship, is challenging the state's power itself to enact such a law. Your Lordship, regarding the fact that substantive part of the transaction or substantive part of the marriage is the subsequent bouquet of rights, Your Lordship. The fact that a marriage was registered in a particular place is not the substantive part of the institution of marriage. It is a procedural part, Your Lordship, nonetheless. But it cannot create a nexus strong enough for the legal status and the subsequent attachment of rights, Your Lordship, to flow outside the state. It is a humble submission that the nexus created here of 7 days registration, Your Lordship, is a mere illusory registration nexus, Your Lordship. It cannot create such a heavy nexus so as to let the legal status flow outside, Your Lordship. Your Lordship, if I may know an issue number 2.
Marriages happen across states.
Yes, Your Lordship.
Right? And each state, each district has a different custom.
Yes, Your Lordship.
Can you on that basis say that supposing somebody who lives in the border of Maharashtra and Madhya Pradesh, supposing they go to the border, marry in Madhya Pradesh and come back to Maharashtra,
Yes, Your Lordship.
would you say that there is like this is an illusory connection to the state of Madhya Pradesh? The reason why I'm asking is because under the Hindu Marriage Act also, jurisdiction of a court is based on where the marriage is solemnized or where the party is settled. Now can you say strike down the Hindu Marriage Act because it creates an illusory state?
Your Lordship, if I may answer this question in 2 points, Your Lordship. Firstly, in the second question was, can we ask to strike down? Yes, Your Lordship. Regarding the second question posed, can we ask to strike down HMA? No, Your Lordship, because HMA is a central legislation which has the protection of 245 subclause 2. But Your Lordship, that connection will not be illusory because it does not create a substantive effect. The FLR is not changing procedures.
Council, let's give you an example of a substantive effect. Suppose you go the other side of the border and you are now from, let's say you come to one of the states where it is a local custom that Sapinda marriages are permitted up to a certain degree.
Yes, Your Lordship.
So first cousins separated by first degree can still marry.
Yes, Your Lordship.
But that is permissible under the existing scheme of laws? In certain customs.
In certain customs, yes, Your Lordship, some exceptions are.
Marriage certificate,
Yes, Your Lordship.
this couple,
Yes, Your Lordship.
who's otherwise in the prohibited degree of separation,
Yes, Your Lordship.
goes to some other jurisdiction
Yes, Your Lordship.
outside the state of the registration of their marriage,
Yes, Your Lordship.
would that make the law which permits such registrations or the law which permits such marriages per se bad in law?
It wouldn't, Your Lordship, because the current scheme of legislation which would allow for such a marriage comes from the central legislation, Your Lordship, not from the states itself. The current scheme of marital institution was like SHMA or SMA, Your Lordships, that might allow for customary exceptions, Your Lordships. These legislations come from the central parliament.
The argument will not help you. Why? Because ultimately this is all state specific. Your argument is appreciable to the extent you are saying because there is a central law, there is no problem. But ultimately, in effect, what is the state doing which is per se bad in law?
Your Lordship, what the state is doing is it is letting the entire union's legal regime change. Your Lordship, if I may give an example of a real scenario that might occur if FLR is
What
applied.
right under the constitution does the union have to a uniform legal regime?
Your Lordship, this comes from Article 254.
Very noble arguments now.
Yes, Your Lordship. Your Lordship, this right to union to oppose such a legislation comes from Article 254 PP dependency, Your Lordship, which would be my second submission for issue to Your Lordship. And
Don't be your second submission.
Yes, Your
Right now
Lordship.
you are in your first submission.
Yes, Your Lordship. Your Lordship, in the Constituent Assembly, Dr. B.R. Ambedkar on 4th November 1948 had clearly specified that in this country, the unique part of the Constitution is that core laws, both civil and criminal, like marriage, can be uniformed without derogating the federal structure. For this, Your Lordship, in the next paragraph, you have prescribed to the fact that such core laws are put in the list 3 of Schedule 7, so that if uniformity is desired, the Parliament can enact the law and bring in uniformity.
Please enact the law.
Your Lordship, there already exists a law. The PSMA creates it.
Second argument.
Yes, Your Lordship. My second argument would answer the question itself, Your Lordship, because second argument is regarding the repugnancy. Your Lordship, the humble submission of the council is that the FLRA stands repugnant to both the PCMA as well as the BSMA, Your Lordship. Your Lordship, as established in the case of N. Karnanidhi versus Union of India, and also elaborated in the case of Hoist Pharmaceuticals, Your Lordship, the test for repugnancy has 4 points to it, Your Lordship. First is that there must be in the same field, which in this case, Your Lordship, it satisfies both for PCMA as well as for PSMA, Your Lordship.
The other side has told us the test.
Yes, Your Lordship.
You tell us how it is impossible to obey both laws.
Yes, Your Lordship. Lordship, with regards to my first submission here, with regards to PCMA, Your Lordship. Your Lordship, PCMA under Section 2 clearly prescribes that for a male to enter the marital institution should have the age of 21 years, Your Lordship. Whereas in FLRA under Section 2 subclause 3, it states that a male may be 18 years of age and can enter.
So here's a simple thing.
Yes, Your Lordship.
Here is the consequence of what you're saying.
Yes, Your Lordship.
Somebody between the age of 18 to 21 can register under FLRA.
Yes.
The moment they turn 21, they can register under BSMA. What's the problem?
Your Lordship, the problem is for the age group of 18 to 21, obedience to the FLRA would by de facto mean disobedience to the PCMA.
How?
Your Lordship, because PCMA does not allow male to enter a marital institution. PCMA is not prescribed to... Yes, Your Lordship.
So here, just a second. That is just a test of validity.
Yes, Your Lordship.
Does that amount to an offense?
Your Lordship, the submission is not some offense here, Your Lordship.
So then there is no question of disobedience.
Yes, Your Lordship.
There is just a different criteria being placed. So for instance,
But Your Lordship,
just to give you an example from another
yes, Your Lordship.
context, once you graduate from a law school,
Yes, Your Lordship.
right, your degree is valid.
Yes, Your Lordship.
But to enter into the legal profession, you have to get a certificate of practice. You cannot appear in court without a certificate of practice. You cannot say that I have a degree.
Yes,
That doesn't make the degree null and void.
No,
You're not saying that I am disobeying the
Your Lordship, the
university.
disobedience comes because the PCMA criminalizes child marriage, Your Lordship. Your Lordship, if I may refer to the PCMA section.
Which provision?
Your Lordship, 4 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 Your Lord Lordship, due to lack of documents, Your Lordship, the council apologizes.
Please, I am telling you, do not just make up stuff. Just
People have voidable marriage, Your Lordship.
point of disobedience is, law says if you do this, I will punish you. Other law says if you don't do this, I will punish you. That is direct inconsistency. Where is that happening?
Your Lordship, the understanding of direct inconsistency is not that one states, if you do this, I will punish you, others says if you don't do this, Your Lordship. The humble submission is that
That's
for
not
the
the
age
question of
group,
impossibility. That's the point of impossibility.
Your Lordship, the point here is that for the age group of male between 18 to 21, if they were to register under the FLRA, it is allowed for Your Lordship. But the same is disobedience of the PCM, Your Lordship, in this case.
So my point is, you're saying disobedience.
Yes, Your Lordship.
I am saying how is that legally disobedience?
Your Lordship, because the... Yes, Your Lordship.
Test laid down in Deepchand.
Yes, Your Lordship.
Test laid down in Hext.
Yes, Your
What are
Lordship.
the facts in Hext Pharmaceuticals?
Your Lordship, the Horse Pharmaceuticals facts is...
Both stands complied, as the brother put it, after the particular years.
Yes, Your Lordship.
In one state 18 years, in another state it is 21, or the central legislation.
Yes, Your Lordship.
Once that age, you cross that age.
But for Lordship, before the cross... Your Lordship, the issue is when they are between the age of 18 to 21.
As long as that age of 18
Yes, Your Lordship.
to 21 is concerned,
Yes, Your Lordship.
in the state where the law is valid, so just giving you
Your Lordship, Your Lordship, the...
21, he goes to the other state.
Your Lordship...
Counsel, your
Yes, Your Lordship.
submission is, I'm sorry to say, misleading. Because under the Prohibition of Child Marriage Act,
Yes, Your Lordship.
only when a male contracts a marriage with a child is there a punishment.
Yes, Your Lordship.
And the age for males is 21,
Yes, Your Lordship.
whereas the age for females is 18.
Yes, Your Lordship, that was my understanding.
Both are 18.
Yes, Your
Where
Lordship.
is the offense?
Your Lordship is offensive both are, that's why Your Lordship, my submission is specific to males. Your Lordship, I apologize if the submissions came out as misleading, but from the initial part of the submissions, I restricted my points to being male between the age of 18 to 21, Your Lordships. Your Lordships, for this group, Your Lordships, since PCMA does not prescribe to only SMA, it prescribes for the whole marital institution, Your Lordship, and is applicable in the state of Germany also as a central legislation. Obedience would entail disobedience because it's a mandation, Your Lordship. PCMA's intent is to punish a public wrong, to prevent it, and to also penalize it, Your Lordship. And that is the intent of the legislation, Your Lordship, so bringing in PCMA. So thereby, Your Lordships, for this group, it would clearly indicate a disobedience to PCMA while they are married under the FLRA, Your Lordships. Your Lordships, if I may sum up, if I may take an extension of 2 minutes, Your Lordship, regarding the second issue with BSMA, Your Lordships. Your Lordships, the repellency with BSMA happens to be a definitional repellency, Your Lordship. Your Lordship, because the BSMA restricts marriage definition between heterosexual couples, whereas the FLRA extends it to homosexual couples also, Your Lordship, there exists a conflict here, Your Lordships. This conflict will be seen much more clearly, Your Lordships, due to the ancillary effects of a marriage. Your Lordships, if I were to be married, Your Lordships, I would also have a bouquet of rights given to me, Your Lordships, such as the laws of intestacy, nomination, pension, gratuity, Your Lordships. All these central legislations, Your Lordships, revolve around the definition of marriage as a heterosexual unit, Your Lordship.
How?
Your Lordship, because in the Indian Supreme Court's case of Supreme,
Facts. Don't go to a different law. You say that the entire framework of legislations relating to pensions, insurance, everything
Yes, Your Lordship.
is hinged on marriage being only a heterosexual institution.
Yes, Your Lordship. Your Lordship, because the central scheme of marriage,
Give us one example.
Your Lordship, the particular facts does not include certain legislations.
How can you make such a statement?
Your Lordship, the union can make such a statement based on the...
You have to give us an example. You can't just
Your Lordship, yes, Your Lordship.
something which only suits your
Yes,
case.
Your Lordship. The example comes from the definition under BSMA itself, Your Lordship. The definition of marriage under BSMA statute would also mean only between a male and a female, Your Lordship.
That's okay, but your point was not BSME.
Yes, Your
Let's
Lordship.
go back to your point. Your point was pensions, insurance,
Yes, Your Lordship.
everything
Your Lordship.
is hinged only on the idea of
Yes, Your Lordship.
heterosexual marriage, which
Yes, Your
in the
Lordship.
context, let me finish.
Yes, Your Lordship.
In the context of Bharatipura may not be true because Pandaren religion recognizes same-sex marriage
Yes, Your Lordship.
between two Pandavans. Are you telling me that marriage is not recognized by law?
Your Lordship, that marriage is governed by the personal laws and that is not the what the union PM. Yes, Your Lordship, under Article...
Why is that so then?
Your Lordship, as I already previously submitted that personal laws for the sake of this argument might not be considered laws specifically, Your Lordships. And Your Lordships, if I may answer the point, yes, Your Lordship.
Point here is, do you recognize those or not?
If you recognize that devout ponderance can marry, Your Lordship.
Perfect. No further issues.
Yes, Your Lordship. If I may answer the first part of your question, Your Lordship, Your Lordship, the definitional challenge of subsequent laws arises because every law ancillary would take its definition from the BSM itself, Your Lordship. Your Lordship, for the sake of any other legislation, in generality when marriage is defined, it would define it as per the central scheme of legislations. And therefore, Your
If
Lordship,
the BSMA is repealed tomorrow, nobody can get married in your country?
Your Lordship, if BSM is repealed under personal laws taken, Your Lordship, but
So then?
there is no secular avenue, Your Lordship. So personal laws states...
Fine.
Yes, Your Lordship.
Point is, the institution of marriage is not created by the Special Marriage Act,
Yes, Your Lordship.
right?
Yes, Your Lordship.
It is an institution which existed much prior.
Much prior to that.
And it
Yes,
is
Your
not the
Lordship.
state saying we are now creating this bracket.
Absolutely, Your Lordship. Absolutely, Your Lordship. Yes.
So then what does it matter if the BSMA specifically recognizes only heterosexual marriage?
Your Lordship, yes,
There
Your
is another law which is recognized.
Your Lordship's FLR, in the context of the current facts, it matters because the FLRA is not only for both heterosexuals and homosexuals, it is also for interfaith couples, Your Lordship. Thereby, it is a secular avenue to recognize homosexual marriage and not merely a personal law avenue, Your Lordship. We recognize the personal law avenue for it.
Ultimately, what you say is, so far as the marriage as on today, as the legislation as existing,
Yes, Your Lordship.
of the laws as existing is concerned,
Yes, Your Lordship.
marriage has been defined in a particular manner.
Yes, Your Lordship.
The expanded meaning cannot be given.
Yes, Lordship. It cannot be given. Yes, Your Lordship. It cannot be given by them, Your Lordship. It has to be given by the Parliament itself, Your Lordship.
That's all right.
Yes, Your Lordship.
Your color, sir.
Yes, Your Lordship. If Your Lordship, sir, no query, I would like to co-counsel for arguing issues number 3 and 4. Much obliged, Your Lordship.
Thank you, Council.
Your Lordships, am I audible, Your Lordships? Your Lordships, I see...
Let him go ahead, sir, if he wants to go.
Thank you, Lordships.
Your Lordships, I seek your permission to move ahead and address issues 3 and 4. With respect to issue 3, Your Lordships, I shall first submit that Section 57 of the BJJ Act and Regulation 5.3 of the Adoption Regulations are constitutional, for they share a rational nexus with the intelligible differentia they seek to create as per the classification doctrine under Article 14. Secondly, Your Lordships, I shall argue that a presumption of constitutionality attaches to the impugn provisions. Now, Article 14, Your Lordships, establishes a constitutional prohibition on discrimination amongst similarly situated persons. To this end, this Honorable Court has devised the classification doctrine, under which a legislation must create an intelligible differentia that shares a rational nexus with the object sought. Hearing, Your Lordships, in my respectful submission, is where on the question of differentia and intelligible differentia is where my learned friends are mistaken. The differentia is not between married and unmarried couples or heterosexual couples and homosexual couples. In my respectful submission, the differentia is between couples married under the BSM and other personal laws on one hand and those married under the FLRA on the other. Now, the reasoning for this, Your Lordships, is on the rational nexus, which has to be connected to the object. The object, through a long line of cases, culminating in superior, is clear. It is to establish and ensure the best interests of the child. Now, following this, Your Lordships, marriage, if I may, is a bouquet of rights. It includes separation, divorce, alimony, maintenance, etc. Now, maintenance of child is also a very important part of such a law. The FLRA and the BSMA have very different ways of going about maintenance, my lords. The FLRA, under section 13, 14 and 15, speaks of maintenance, if I may take my lords to those sections. With my lords. Section 13, Your Lordships, is the only section that deals with the maintenance of the child. Section 14 and 15, on the other hand, only mention parties to the suit. What is more, your lordships, is that a child can only be entitled to maintenance when the when one of the parties to the marriage files a suit for judicial separation or divorce, which means during the sustenance of the marriage, the child is deprived of any entitlement for maintenance. Therefore,
Where are you getting that? Because there's always section 125. How do you mean deprive?
Your lordships,
Parents maintain children only when the law says they have to maintain children.
your lordships, on that particular point, it is acting as a protection where the parents are not.
No, this is a completely different point you're getting to. You are saying there is no right to maintenance when a child is, when parents are married. Right is a legal creation.
Lordships, there is no protection or legal framework under which a child or
I'm saying if a child is not maintained, there is section 125 CRPC or its equivalent under the new legislation.
if I may
Protection there.
if I may convey to my lords how section 125 or now 144 BNSS does not apply.
Right.
Your lordships, it mentions by its very term, the section has always mentioned his wife. Now in Superior, Honorable Supreme Court of India has been very clear that gender-specific terminology cannot be read as gender-neutral terminology. Therefore, when you say his wife, it is meant only for a heterosexual couple.
We're not talking about wife, we're talking about children. What does 125, 144 say?
Your lordships, as far as the term his wife is concerned, it is used.
That's not what we're talking about. We are saying there are already existing provisions which provide for that if a child is not being maintained, that the child shall be allowed to approach the court and seek maintenance. So what legal provision you're saying is not
Lordships, those provisions are especially missing from the FLRA. A couple married under the FLRA cannot approach any.
Where is it in BSMA?
Your lordships, the couples married under the BSMA have the recourse of 144.
Counsel, don't shift. We are talking a very simple point here. You started off with section 57 JJ Act.
Lordships.
Why would you talk about 57 JJ Act? It's for the interest of the child.
Lordships.
You are now saying that the child is not protected under the FLRA.
Lordships.
Where is it protected under BSMA? You are drawing a distinction between BSMA and FLRA, saying that one is an inferior legislation compared to the other as far as children are concerned. Is that what you're saying?
Lordships.
So show us how children under FLRA are less protected as opposed to BSMA.
Your lordships, the point of perhaps BSMA and FLRA can also be, as I was trying to say, is through perhaps 144 and the application. My point is, if I just may 10 seconds, sir. Sure. 10 seconds, your lordships. Your lordships, even if the BSMA had the same scheme as the FLRA, my respectful submission, they would also be entitled to the recourse under the BNSS or the CRPC. That recourse is also not still.
Let's please be clear here. Nowhere does BNSS or CRPC say only legitimate children under a law already passed.
Absolutely.
Because here's the thing. CRPC in Indian context came into existence before there was a Hindu Marriage Act, before there was a Muslim Personal Law, Shariat Act, right? So it couldn't have been that only statutorily recognized marriages children have any rights under, no other children have any rights. Correct? So just because there are laws doesn't mean you now read back into the Code of Criminal Procedure some requirement that only certain kinds of laws can validate relationships and certain kind of laws cannot.
That is not
What he wanted to say is, 55 and above the provision also, they are protections.
Yes.
They are not the positive mandates, but they are protections.
Right.
So that's how you want.
lordship, that is obliged, much obliged. Your
But
lordship.
Counsel, you missed out on two things in 144. 144 begins with person. You are trying to read in 1A his wife, but that is not even relevant here. Because person, as you would acknowledge, is a gender neutral term, and as has already been pointed out to you, 1B says legitimate or illegitimate child. So a person has to maintain, a person having sufficient means has to maintain their legitimate or illegitimate child.
I bow down, your lordships, 100%. The issue, my lords, is in the holding also of Superior. Now, when the gender-specific terminology of SMA and these other laws were in challenge, Justice Bhatt, speaking for himself, and Justice Hima Kohli, was very clear that terminology and Section 144 itself speaks only to heterosexual couples. It does not speak to homosexual couples. So by
Citing
citing
a foreign judgment before us, which at best would be persuasive, and we hereby clarify that that does not apply to our country. Let's move on. Also,
Your
you
Lordship-
just stand as a union. As the union, while it is your duty, parents' patria jurisdiction, which you want to assume, to provide for welfare of all children, more so children who are part of now queer community, because they themselves are in need of protection. Now you want to shirk from your responsibility and argue before constitutional court that no, please don't grant them these entitlements because I am shirking from my duty.
my lords may see that legislative prerogative is something, and the intention of the legislature is something very different in this particular case as far as enacting a new law. The prerogative of the union in this present case is to make sure that there is another realm where also any couple married under the FLRA cannot be adopting because of the best interest of the child, if I may come to that. Even if your lordships may find and read down on maintenance or perhaps read in on maintenance, there is another aspect which is very clear, your lordships, and explicit, which is that there is a lack of any provision specifying any prohibition on degrees of prohibited relationships. If I may take your lordships to the solemnization of marriage in section 2 of the Act. If I'm with my lords. Your lordships will find that it has no mention of prohibition on couples marrying who are part of degrees of prohibited relationship. What is more, your lordships, is under section 5 of the Act. If I may again guide your lordships to go. It says that a marriage officer may only deny marriage if conditions under section 2 are not fulfilled. The same is the case with registration of marriages in section 7. In my respectful submission, therefore, siblings, lineal descendants, and people who are step-parents, perhaps stepchildren, can marry under the FLRA and fulfill the conditions therein. Now, a legislation which is inherently so lax in allowing incestuous relationships to form the sacrosanct bond of marriage cannot be then allowed to adopt, because those relationships cannot be within the best interest of the child.
That is your concern. That is at best a case of causes homicis. We'll fill it in. You're at the constitutional court. We can always provide for a causes homicis.
I bow down to the magnanimity of your power, your lordships. The only issue is that that would again be a subsequent action, perhaps. The intelligible differentia sustained as far as the cause of action in the present case is concerned.
How would it be subsequent? Age-old premises when a constitutional court interprets a legislation.
Lordships.
It would relate back to the date of enactment of legislation.
Lordships, even then, in that particular case, it is validly, your lordships, it is validly omitted in this particular case, especially the ban on incestuous relationships is validly omitted from the conditions, as also seen through section 5, where it limits itself, where there is no clause of public interest, as in perhaps other legislations. So a marriage officer must...
Counsel, can we strike down a law on the basis of, or can we uphold a law on the basis that it protects some remote hypothetical as opposed to the real people it's affecting?
Yes, your lordships. For that, your lordships, if I may take your lordships to my argument on presumption of constitutionality, that will...
Keep that aside. I'm asking for a legal proposition. Give me an example, okay? Give me an example where any court has struck down a law or upheld a law on the remote possibility of something that could happen as opposed to something that has already happened.
Lordships, on that very fact, the Honorable Indian Supreme Court, in the case of UP versus Kartar Singh, which was a division bench judgment, held that a legislation need not be struck down.
What were the facts of the case?
Your lordships, the facts of the case were that there were government employees of a particular department of the government that were claiming parity with another class of government employees, and on that there was a section, Article 14 challenge, and there the presumption of constitutionality as a question came up, wherein the court held that as long as there is a line of facts which reasonably satisfy the classification made, it is to be upheld. Now, these line of facts, according to the court, need not be proven. it need not be shown that there is an incestuous couple that is actually registered marriage.
I still don't understand what was the line of facts in that case.
Your Lordships, the facts basically were that there is a one class of government employees who are claiming parity for a similar salary with another class of government employees. The differentiation was between certain managerial positions that the latter class was occupying.
Yes.
On that, the question of presumption of constitutionality is on that Article 14 is being raised, wherein it is alleged that perhaps the conditions that you need to be the former class of the government employee that is challenging are not enough so that to qualify you for those managerial positions that you are claiming parity with. On that, the Honorable Indian Supreme Court has held that as long as the facts reasonably classify or satisfy intelligible differential that is being made, they need not be proven that yes, every single government employee in the former class is not qualified.
So counsel, that goes directly against you, because here we have a valid law as on today. That law says these relationships are counted as marriage. In fact, BSMA is not an all-encompassing law, because there are certain kinds of relationships which the BSMA does not recognize, which are recognized under other laws. Those couples would be entitled to adopt. We are just saying FLRA, we are not allowing them to adopt. And that couple is right here before us. We don't need to look at your hypotheticals. We will strike down the law itself on the basis of the clear and straightforward discrimination. Forget about classification. Where is the classification here? There is clear discrimination.
Your Lordships, the discrimination again is not based on the discrimination which is protected under 15 or 14. The discrimination can only be if the discrimination based on sexual orientation. Yes. It is in my respectful submission, if it was a heterosexual couple married under the FLRA that had approached, then they would also be denied on the same basis.
It doesn't mean that we're going to be discriminating towards more people doesn't make the law better.
Your Lordship, the discrimination is not on protected measures.
The fact of this.
You also see your time and probably your,
if I may continue to issue for a minute.
I'm only trying to help you in the sense.
Much obliged.
Focus, keep on answering our questions. We have plenty. So unless you bring us to what you want to convey with respect to this case, we will be losing this case.
Your Lordships, my argument is simple, Your Lordships. My prayer is simple with regards to this particular case. It is that Section 57 of the BJJ Act and Regulation 5.3 must be
What
upheld.
is left out now?
Lordships, issue 4, if I may jump to it. Your Lordships, thank you so much. Your Lordships, firstly, I would argue that the judgment in Kaushal Kishore for horizontal application of fundamental rights must be treated as per incurium by this honorable court. The reason being that in Z Telefilms, a coordinate bench, a constitutional bench of the Indian Supreme Court refused to declare a claim that Article 19 can be enforced horizontally. That judgment is entirely overturned by the judgment in Kaushal Kishore. Furthermore, Your Lordships, the judgment in Pradeep Kumar Biswas, which is delivered by a 7-judge bench, which came up through a challenge to the judgment in Sabhajit Tiwari, was very clear on laying down comprehensive tests to determine the doctrine of state action and therefore laying down the framework of Article 12. That is also invisibilized by the judgment in Kaushal Kishore. Therefore, given all of this, and the fact that the honorable judges have discussed both of these judgments in detail, one conclusion that may be made is that perhaps they did not intend to overturn it, otherwise they would have been referred to a larger bench. And even if they have misapplied the law, in any case for the purposes of the Supreme Court of Bhartipura, it must be treated as per incurium for the present case, because fundamental rights can't be given that. Secondly, on Article 226, Your Lordships, at the very outset, in Federal Bank's case, the Honorable Indian Supreme Court has held that mere regulatory provisions that govern the activities of private entities do not make those private entities part of the state under 12 or part of other authorities and persons as per Article 226. Now, on that, Your Lordships, the bench is very clear on that the private bank that that is being regulated by the RBI in all its activities is prima facie not performing any public duty. That is the judgment and the holding of the case. It follows therefore that prima facie Data Bank is also not performing a public duty on account of its banking services. But in this particular case, if we may come to the facts of the case and judge it as far as the test of public duty that is given is there. There are two case laws that comprehensively lay down the test. Firstly, in Andi Mukta Sadguru, Your Lordships, the Honorable Indian Supreme Court has laid down a three-pronged test.
And we have taken that so far as those aspects are concerned. Next point.
Lordships, yes, Lordships.
Spend time on that, you can spend that time.
Lordships, the public duty in this particular case must not be of a discretionary character. Now, this is an HR policy that is under a challenge. This HR policy is entirely discretionary. There is no statutory mandate that transfer must also come along with spousal company. There is also no statute that is mandating that, there is also no fundamental right violation as it is not a law as per Article 13. Therefore, can an HR policy be set aside by the Honorable High Court on the question of writ jurisdiction? That is the question, and the answer has to be no as per this thing. Even if we look at the judgment in Janet Jayapal, which talks of positive obligation vis-a-vis the appellants and of legitimate expectation, which is also mentioned. Firstly, Your Lordships, legitimate expectation is of a nature of public law. Secondly, this positive obligation is not being imposed. It is there on a discretionary level.
Counsel, it's not a question of discrimination. Can Data Bank say we will recognize some laws and not recognize other laws?
Your Lordships, Data Bank, the question is that for it has to be a mandate of the law to do so. The mandate does not exist, Your
Can I
Lordships.
say we will ignore this law because this law also has a mandate? This law's mandate is a registration under this act is deemed as a marriage for all purposes. Can you say we will read FLRA as a bank excluding this provision?
Your Lordships, in that case, the cause of action would mean that an alternate efficacious remedy under civil code for perhaps a contractual dispute, etc. may be brought in, because at the core of the public duty that is being alleged is the HR policy, which is of a discretionary character. Now, following that, Your Lordships,
Let me just take one step back. Are you saying civil courts have an even wider jurisdiction than high courts under 226?
not at all, Your Lordships.
Then?
Not at all. Your Lordships, the high courts, as per Andi Mukta Sadguru and other judgments, can take litigation under Article 226 only when there is no alternate remedy available, where fundamental rights are not alleged.
What is the remedy in civil courts? What is the remedy being asked in a civil court?
Your Lordships, though the Moot proposition is moot on it prima facie, the HR policy is rising via either a condition to service or via contract or via the fact of employee-employer relation. All of these are governed at the basal level with the civil code. Your Lordships, it would open the floodgates of litigation in high courts if...
Let's not worry about floodgates. Very simple point. What would be the relief that the petitioners could claim in a civil court?
Your Lordships, if there is indeed a legitimate expectation coming from perhaps a contract, then it is a breach of contract.
Because counsel, you've made the point that it is an alternate efficacious remedy.
Lordship.
So tell us what is that alternate efficacious remedy? It can't just say go to civil court. That is not what is meant by the
Absolutely
term.
not.
It means that the relief that you are asking for, that court can also grant. So what is that relief?
Lordships. First of all, on that relief, the reason the specificity is perhaps missing is, as I said, the Moot proposition is moot on how it rises.
Law. This is a relief in law. There is a code of civil procedure which governs.
Lordships.
Please tell us what relief are the petitioners supposed to claim?
Your Lordships, again, the petitioners may go in breach of contract, and on those levels, because they are claiming that
Breach of contract is not a relief. Breach of contract is a ground.
damages, Your Lordships. They may go for damages, they may go for multiple other things, they may go for further this thing of contracts.
See, counsel, what is the relief they are asking for from the High Court? saying that, they're not saying set aside the entire transfer policy. They are saying interpret the transfer policy and issue a mandamus to them to transfer me along with where my partner is, right? What is the relief that you're going to go to civil court and ask for?
That the contract be abided by, if that is the argument.
That is not a relief, that is a ground that you're asking. Anyway, let's move on, I think we're running out of time. Please go on.
Relief is a payoff.
Your Lordship, if I may give the
Yeah.
Your Lordships, the respondents pray that the legislative, that this Honorable Court declared that the Legislative Assembly of Gormania did not possess the legislative competence to enact the FLRA, that no state, secondly, that no state is under an obligation to recognize the FLRA, that the FLRA suffers from being repugnant to both the BSMA and the PCMAs and therefore void pro tanto. Penultimately, Your Lordships, we pray that Narmera must be made to relocate to either Gormania or tender her resignation to Beta Bank as per the conditional interim order that was passed by this Honorable Court. That Section 57 of the BJJ Act and Regulation 5.3 of the Adoption Regulations must be upheld and be declared that the High Court of Gormania cannot set aside the policy of Beta Bank because it is not a public entity under Article 226. The pleasure I will very much.
The exercise of jurisdiction by this court in SL,
I can't, Lordship, I can't.
it is very, very limited. You are not concentrating on it at all. That's all I'm saying. Not the same.
With the rebuttals, Your Lordships. Your Lordships, the appellants have certain rebuttals to the arguments presented by the respondents in their speech. Firstly, Your Lordships, the respondents talked about how centre is the only legislature which can deal with marriage laws, Your Lordships. The centre cannot be the only legislature which deals with matters of marriage. If this was the intention of entry 5 list 3, Your Lordships, then the aspect of marriage would have never been included in the concurrent list by the virtue of the drafting of the constitution. Since marriage is included in the concurrent list, states are inherently competent to enact legislations on the subject matter of marriage, Your Lordships. Secondly, Your Lordships, the respondents...
There is already a pre-existing legislation of the centre. What are the other aspects which you refer to?
Your Lordships,
Consultation. There is already a pre-existing law of the centre from the concurrent list, in which case, before you enact a law or what is required to be.
Your Lordships, if a state legislature is enacting a law based on marriage under the concurrent list, it has to be, it needs to pass the test of repugnancy. And Your Lordships,
Apart from that, then
apart from that, Your Lordship, the presidential assent needs to be established or taken.
is the presidential assent
Your Lordships,
obtained already or not?
presidential assent is only required when repugnancy is established. Unless and until repugnancy is conclusively established, in this case after the decision of this court, only can the presidential assent be required or mandated. Unless and until it is not done, if presidential assent is a mandate before repugnancy is established.
Counsel, is this your suggestion that whenever they go for presidential assent, they wait for a constitutional court to pronounce repugnancy and only then presidential assent is sought?
No, Your Lordships.
Is it that you yourself declare that there is no repugnancy?
Your Lordships.
Is it that you yourself will say that there is no repugnancy?
No, Your Lordships. It is the discretion of the governor to check whether there is a repugnancy or not, and if the governor under his discretion feels that there is no repugnancy, then the governor may not send the bill for presidential assent under Article 254(2). And in that case, presidential assent would not be required. Secondly, Your Lordships, the counsel for the respondents with respect to the third submission argued that there is differentiation arising between BSMA and FLRA, Your Lordships. This position is entirely incorrect, Your Lordships, to argue for the third submission, because third submission deals with the relationship between children and parents, and it has to be this relationship with respect to best interest needs to be defended as far as Article 14 and 15 are concerned, and the respondents did not argue sufficiently on that because, Your Lordships, in the case of Navtej Singh Johar, the effect of any differentiation was given paramount importance by Justice Chandrachud, and we believe that the effect of this differentiation under these provisions is leading to exclusion of all queer couples and is indirectly discriminating against them as far as these provisions are concerned. Secondly, Your Lordships, the councils made reference to the fact that of Kaushal Kishore. Your Lordships, in Kaushal Kishore, paragraph 77, the court has taken due note of the expansive jurisprudence of Article 12, and then it has laid down its ratio that horizontality is an expansion, and it needs to be considered on a case-to-case basis when the actions of a private entity are before the court. And in this case, as already established by the appellants, Beta Bank's actions are going in teeth and in violation of Article 15 of the Constitution and violating the fundamental rights. Those would be the rebuttals on behalf of the appellants.
With regards to issue 1 and extraterritoriality, Your Lordships, firstly I would just like to produce a possible hypothetical if the FLRA is abided by. The FLRA by its very term makes sure or mandates that only one party to the couple is actually present for 7 days. So what happens is that one of the parties is there in Gormania for 7 days. On the day of the marriage, the other flies in a morning flight, gets married, and by evening flight they fly out married, and now according to the appellants, their marriage has to be regulated and recognized by rest of all states. That cannot be the measure of territorial nexus. On the second issue, Lordships, on the contention of Article 261, if I may, the Honorable Punjab and Haryana High Court has held that the clause in 261 is not an absolute unqualified constitutional command, because if the appellant's version of Article 261, which was also argued in the case, is to be believed, then on that, Your Lordships, every single law made by every single state would thereafter be applicable in every other state of the union, which is again creates a position where Article 245 becomes inoperative. Beyond this, Your Lordships, there is also the fact that Article 261 is adjudged to have an evidentiary value and contain an evidentiary rule. What this means is that their marriage certificate, when it travels with them and falls in the hands of an official of another state, that official has to agree that it is authentic. Why? Because it is notarized and given by a state officer of state of Gormania. However, he need not recognize that certificate. And that is the distinction between recognition and authenticity. So even if 261 is to be believed, it is only in authenticity and not in substantive recognition. Your Lordships, further to address the query raised on alternate efficacious remedy, perhaps a remedy of specific performance is also available. However, it is very difficult to suggest where that remedy lies at the end of the day or in what court, because the moot proposition is moot in what way the policy is affecting, or how the policy is coming to birth and in what relation it has come to birth. For example, there is an argument perhaps that under the Industrial Disputes Act, however, even then there are certain exceptions. But if the appellants are meeting certain conditions, perhaps under there also an alternative efficacious remedy is available. So on these grounds, the appellants have also acted in complete defiance of the judgment in Superior by again trying to review the decision in Superior by making the differentia between married and unmarried couples,
because that differentia has already been sustained in the case of superior. So therefore, the contention that on that differentia, that unmarried couple should also be allowed to adopt is again something that has already been adjudged to be to not be allowed under paragraph 124 of Justice Bhatt's judgment in Supreme. With that, your lordships, it was a pleasure arguing before your bench. Thank you. Thank you, Lordship.
Let the names.
This is it. Wonderful, both of you.
Thank you all for joining this. The judges will be scoring you all right now. Thank you all for showing up in large numbers. The results will be out in the valedictory ceremony, obviously. Fine. Have some patience, man.
Good job. Good job. That was amazing, yeah.